Thanks, Steve, and a special thanks to DealFlow and all of your support staff who've been great throughout the conference thus far. And we were at your first conference and everyone since, and they're quite incredible. And this is, I think, the biggest turnout they've ever had for a SPAC conference. So kudos to you, to Steve. My name is Steve Nelson. I'm president and chairman of Continental Stock Transfer and Trust Company. The title of this panel is Litigation and Enforcement Trends Shaping the Next Phase of the SPAC Market. I'm going to let each of my co-panelists introduce themselves. First, a little background. Continental Stock Transfer and Trust Company is pleased to be a sponsor. Again, this year, Continental is the largest SPAC transfer agent in the United States. We were in the room when the first SPAC was created, New Generation SPAC. I see Dave Nussbaum in the audience, and he was in the room of 3. So that took place in 2003. We've done over 1,600 SPAC IPOs since that time, over 800 business combinations which we've processed, and I'm happy to say we've never paid out less than full value on the trust account in any business combination. So that's a great indicator for the SPAC market. So next on the horizon, Cynthia, and Steve did a great job with your last name. Please go ahead.
Good morning, everyone. My name is Cynthia Ananda Jayasekram. Steve did do an excellent job with pronunciation. I am a partner in the corporate M&A and capital markets team at Ogier in the Cayman Islands. My practice is very broad. It spans all manner of public and private markets as well. But in terms of the firm, we're one of the leading offshore advisors in this space. We sponsored this conference for a number of years, and we're very happy to be back this year. And as Steve says, thanks very much to DealFlow for having us. As a firm, we practice the laws of the Cayman Islands, British Virgin Islands, Jersey, Guernsey, Luxembourg, and Ireland. And we've recently just announced an alliance in Bermuda. So across all of those jurisdictions, it's been a great opportunity to see the landscape develop. And it's great to have the opportunity today to speak on this panel and talk a little bit more about that.
Thank you, Cynthia. Mike, I'd also lean into the microphones because I have a feeling you'll do better. Go ahead.
Good afternoon, everyone. Mike Tomasulo, Senior Managing Partner with the Baldwin Group. Run our national management liability practice. So my team has a specialized focus on public D&O insurance for IPOs, SPACs, de-SPACs. I think I worked on my first SPAC about 20 years ago on the carrier side when I was with AIG. We're fortunate enough at Baldwin, we have the exclusive partnership with the NASDAQ stock market. So we've actually created an exclusive program for NASDAQ SPACs with certain policy terms that are unavailable anywhere else. So it's given us the ability probably to speak with 80% of the SPACs that have gone off in the last 2 years and probably work with 20-25% of them. So happy to be here and happy to be part of this panel today.
Thank you. And last but definitely not least, Dan Foreman, partner at Lowenstein Sandler.
Thank you. Thank you and good morning. I'm Daniel Foreman, a capital markets partner at Lowenstein Sandler. I advise public and private companies, investment banks, private equity sponsors, and venture funds on capital markets transactions across the full life cycle. IPOs, secondaries, debt offers, tender offers, restructurings, and private placements, as well as board governance matters. At Lowenstein Sandler, a leading national firm with over 400 attorneys, we focus on serving high-growth companies, and I work alongside our capital markets, M&A, SEC, and complex litigation teams to guide clients through the full SPAC lifecycle, from IPOs to de-SPACs to public company life and investigations and disputes when they occur. Over the last decade, a significant portion of my practice has centered on SPACs and de-SPACs. We've helped sponsors, targets, and financing sources structure and execute transactions. And I also work closely with management teams and boards on SEC reporting and corporate governance, including in the de-SPAC context. I look forward today to discussing practical steps boards, sponsors, and targets can take to reduce their exposure, their liability exposure, and talk about process design, related party oversight, projections and disclosure controls, redemption dynamics, and post-close reporting, so the transactions that we work on together can withstand scrutiny in the courts and from the SEC. And also, just a fun fact, I think all four of us worked on the RMG ML SPAC, which priced last night a $200 million SPAC. So we're all a great team up here and look forward to continuing that today.
That is a quirky fact, but you know, it's a big year, and this may end up being the second biggest year for SPACs of all time. So we'll see if we can ride the wave. But in the interim, first question out to Cynthia and Dan, and that is, where are we actually seeing litigation risk crystallize in SPAC and de-SPAC transactions, and how does that differ between U.S. and offshore structures? Why don't we give the young lady, I think we should give you the first shot.
Very, very happy to take that one. On the Cayman side, it's interesting. I mean, as you mentioned, the recent SPAC boom, obviously it's taken a while for these types of cases to be trickling through Cayman, for us to be hearing them through the Cayman courts. And we are slowly seeing a lot of following the shift over the last few years, really, from Delaware being the primary jurisdiction of SPAC and sponsoring corporation through to fundamentally Cayman being the number one jurisdiction in that space. In saying that, I think, and I know Daniel will touch on this, but one of the key things that, you know, it's important, I think, for us to point out about Cayman as a jurisdiction is it is a lot more selective and more structurally focused when it comes to these types of claims. There's a few reasons for that. One is, I think there are higher barriers just in terms of procedurally who can bring a claim, what their standing is, and the types of claims that we would be, you know, looking to see adjudicated in Cayman courts. The second is, and I think this is a fundamental distinction, we are a loser pays regime, which really shifts the hurdle from our perspective. We're seeing far less opportunistic claims, and we're really testing whether or not there are merits before you know, both practitioners are taking them on, but we're actually seeing the litigation come through in the courts. While we haven't seen necessarily claims come through on all of these areas, I do just want to flag some of the sorts of things that might be worthwhile considering as you are structuring Cayman SPACs. Obviously, fiduciary duties are a core part of where we might see litigation. We haven't necessarily seen a lot of that yet just because of the parameters of the shareholders' ability to bring those types of claims. But obviously, for all directors, that must be a paramount consideration for them. The second, and Steve, I think you'll touch on this as well, is how the trust account really factors into things. When can creditors make claims against that? When and at all can shareholders make claims against that as well? And how would that play out? Obviously, conflicts for sponsor economics, that's a really big thing that we're trying to kind of think about on the front end and make sure that we are putting in place the right processes to really engineer around that. Disclosure, misrepresentation, there has been recent case law around that in the Cayman Islands, and I think that's an interesting one to point out because quite often we think that sits under the US securities perspective, and obviously it does, but there are directors' duties and the likes that come into play when we're thinking about what we're actually putting out to the market on behalf of these SPACs. And then finally, when we get to the de-SPAC side of things, obviously you need to be thinking about how you're structuring these deals. So when we're thinking about termination rights, when we're thinking about fiduciary outs, when we're thinking about earnouts, you know, all of these things are really important to think about on the front end, so this litigation risk that we're trying to protect for doesn't actually crystallize. And I guess just on that, and before I hand over to Daniel to talk about the US perspective, one thing to really highlight from a Cayman perspective that is a distinction is that the courts there, for public policy reasons, will primarily emphasize what is in the constitutional documents of the entity, and they will also look to ensure that there is commercial certainty in the way that those claims are being heard. And so, you know, from that perspective, you know, party autonomy is a really big consideration for us, something we're really looking to protect, and I think is quite a big distinction from some of the approaches we've seen in the Delaware courts.
Yeah, thank you, Cynthia. So I guess just first to start, when we're structuring SPACs, generally I think the default now, and most people in the room would share this, is that you should really look to the Cayman Islands, given the protections, the structure, and the positioning of those courts when they're facing de-SPAC transactions that come up before them. So always have those conversations early on with the sponsor, with the de-SPAC target about the process, and loop Cayman counsel in early. That said, we are seeing in Delaware still a number of cases coming through, given it takes time for things to move through court. So we're still seeing a lot of cases, a lot of actions come through based on the last SPAC cycle. And so where these cases are being brought is in Delaware. I think that's the primary battleground where we're seeing SPAC fiduciary claims. I would say that the focus is generally on two areas. One, whether the SPAC fiduciaries have impaired public stockholders' redemption rights through materially deficient disclosure. And so I think I'd characterize one, the main issue for us to think about is deficient disclosure, claims around that. And when we're looking to protect our clients, always focusing on the disclosure, particularly in the de-SPAC proxy. The other piece, and this is where case law comes in and is really important to stay on top of, is the inherent sponsor and director incentives that made the de-SPAC transaction conflicted from the outset. And so I think here we go back to where Delaware has come out through its rulings on a multi-plan, a case there where they viewed the case coming out that the directors should be reviewed under the entire fairness standard. And just for a recap, generally in Delaware, the business judgment rule applies. There's a presumption that the directors acted on an informed basis, in good faith, and in the honest belief that the action was in the best interest of the corporation. And so when you have someone trying to challenge that, when a plaintiff comes in, they first have to rebut that presumption, and that's a very difficult thing to do. However, with Delaware's shift in multi-plans, when they look at de-SPAC transactions, they move to an entire fairness standard, which is the most searching form of judicial scrutiny. So the burden generally shifts to the defendants, and that will be our clients, right? The SPAC, the sponsor, the board of directors, and they must prove that the transaction was the product of a fair process, so there has to be fair dealing, and that it resulted in a fair price. And so when we're in that context, there's a lot of additional procedures and protections that we want to consider for a Delaware SPAC looking at a de-SPAC transaction. So I think that's where we'll leave it on the litigation front and come back to SEC enforcement, which actually still is actually should be a focus of the folks in this room.
Before we go to the next question with Mike, an earlier panel referred to the fact that multi-plan was succeeded by the Hennessy decision. Does that affect any of your points?
Yeah, I think Hennessy is there, and I think that's a helpful case in structuring and thinking about and trying to blunt the impact of a potential finding yourself in Delaware court. But I still think we need to consider the intense scrutiny that de-SPAC transactions will face in Delaware courts, particularly where there are other elements of the transaction where sponsors, directors, and other participants in the transaction may have interests.
Great, thank you. Okay, Mike, from a D&O broker's perspective, what litigation trends are sponsors and boards underestimating today?
Yeah, so I think the first thing that sponsors need to understand in regarding litigation and their D&O insurance is, are they covered? Because I don't think most sponsors realize that the majority of D&O policies, the way they're written, do not extend coverage to the sponsor. So that's an important caveat that they need to make sure that they're added at least as a co-defendant for claims brought against them. I think some of the other issues that SPACs need to understand is that a lot of SPACs, I think, view the litigation exposure as a SPAC at zero. And it's not zero, okay? It's not the same as when you de-SPAC, but it's also not zero. I've seen a number of kind of messy claims at the SPAC level, whether it's within liquidation or it's on a breakup with a target that didn't go correctly. There are definite risks involved for the SPAC in the pre-de-SPAC timeframe. I think the other piece of that is a lot of SPACs view the insurance as a commodity. How cheap can we get this, and how can we get this put in place quickly and cheaply, without looking at some of the terms and the conditions and understanding some of the nuances of how to best protect. And I think we can get into that a little later. but I think understanding that while insurance is not the most exciting part of the SPAC process, it is your first and sometimes only line of defense when litigation occurs.
Makes sense. Okay, back to Cynthia and Daniel. From a director's perspective, how do the legal frameworks differ between Delaware and Cayman, and particularly around concepts like the business judgment rule, entire fairness, and fiduciary duties? How do they differ? Cynthia, why don't you go ahead?
Perfect. I guess if I had $1 for every time somebody said that Cayman was just like Delaware, but maybe slightly different, I probably wouldn't need to be at this panel or practicing. But I think, at a high level, the core fiduciary duties that we're thinking about for these directors are similar. I mean, we're thinking about, as you said, we're acting in good faith. We're thinking about best interests of the company, which from a Cayman perspective is all the shareholders taken as a whole. We are thinking about acting for a proper purpose, and we are fundamentally thinking about how we avoid conflicts, which I think is a really big part of the litigation risk that we're trying to kind of protect for. But in saying all of that, while the concepts are similar, the frameworks are actually quite different between Cayman and Delaware. And a key example of that, for example, is the duty of care. So the duty of care in Cayman is a non-fiduciary duty, meaning that when it gets assessed, it's assessed much like a negligence claim. There's first a general standard about what would a reasonable director do of the same sorts of care, skill, and experience. But then there's also a subjective test about what that specific director actually did, and that is a different way to how that particular duty would be assessed if it were to come through Delaware courts. Daniel touched on this. We talked a little bit about kind of the different doctrines that exist in Delaware. There is no equivalent doctrine to the business judgment rule or the entire fairness standard from a Cayman perspective. In saying that, though, we are looking to many of the same procedural frameworks that would protect for the same thing. So the same robustness of decision-making, looking at taking very comprehensive minutes, looking at analysing and really having boards engage with the matters that are at hand before them. In terms of Cayman perspective, while there is no equivalent doctrine per se, the frameworks and the structures that we put in place are really, really critical to basically putting in place in practice a similar sort of standard.
Yeah, thank you. So, I think we advise our directors similarly, whether they're, situated, the SPAC is situated in Cayman or Delaware, and I think you hit on a number of the key points. And we already talked about the business judgment rule and entire fairness, but I think what I would focus on as we approach a de-SPAC situation for directors and advising, how management teams should work with their directors as well, is keeping the board and the directors informed throughout the process, keeping them aware of how the search for a target is going, who they've, spoken to, what the terms seem to be about the kind of the broader market, so that when a deal comes, they can be knowledgeable about the context in which that deal is coming. And it's really important that process is documented. You mentioned keeping good minutes. I think, SPACs are certainly on a better foot now than they were, but that could swing around as well. And many SPACs that are having, very good deals now could face litigation in a few years. So I think the importance of keeping good minutes, good records of these processes is really important for the board. I think it's important that boards involved and understands the diligence that management is doing and receives the appropriate information about the company, what management has done to diligence, that they ask questions. And then, projections and forward-looking information is always extremely important as well. That's an SEC focus. That's also a focus in private litigation. So managing that process very carefully and ensuring that the information that the directors are making a decision on has been properly vetted, digested, reviewed by advisors so that they're getting the right information and not, too much information that serves as a distraction or noise or that otherwise they, aren't going to be basing their decision on that could hurt them in litigation later. So I think record-keeping process, informed directors, and then also, being reminded and understanding where their obligations lie, in the best interest of the corporation, in the case of Delaware, to its stockholders as well.
So I'm going to jump to a different area, and I'm going to play panelist. So I'll ask myself the question, which revolves around how has the law on creditors' rights for SPAC transactions evolved over the last 5 or 10 years. And it's really evolved dramatically. Literally hundreds of SPAC prospectuses for IPOs, probably all of them, for many years included a provision which said it was a disclosure, a risk disclosure, saying in certain circumstances, if the company liquidates, creditors may jump in front of shareholders who are holding in trust in certain circumstances. And there were a lot of people who believed that that was the law, and as applied, that it would affect the trust shareholders under the IMTA. Well, in fact, we took a different view in our role as trustee in various situations where we would receive claims before the company actually went into liquidation, and the company may be a Cayman company, and we'd get letters from liquidators in Caymans saying, don't distribute the trust fund because there are creditors' claims. And when we looked at it, we became convinced that the trust was sacrosanct and the trust shareholders needed to be protected. And in the absence of a court order, underlined, in the absence of a court order, we distributed upon the liquidation in several cases, including Fat Projects, Rose Hill, and a couple of others. As the law started to come more into focus, there was a case in Texas, in bankruptcy court in Texas, where the company tried to liquidate and go through the bankruptcy process, and actually the principals were quite conflicted because they were making claims as creditors of other entities of the SPAC. Nobody was there to protect the shareholders' interests, so we had to jump in and literally litigate in Texas bankruptcy court to protect the trust. And we got a very favorable decision, which was really the first of its kind, which says creditors don't jump in front of SPAC shareholders, and the motion to put that case through Chapter 7 was denied, and the creditors' claims disappeared. Similarly, there were a couple of other cases where law firms sought to get paid as creditors of their SPACs, the most notable being 26 Capital. And again, we were instructed by the court in that case, it was Delaware Chancery Court, that we couldn't distribute because of this potential creditor's claim. But fortunately, in that case, there was a settlement which didn't affect the law in this area, and we paid out to shareholders. So it's an evolving area, but we've had to jump in as trustee to protect the rights of SPAC trusts, shareholders, and so far we've been successful. So we'll see how that emerges. Any comments? Okay. It's the non-litigators, right? Okay. To Michael, what are the sponsors and independent directors asking about D&O insurance today that they weren't asking 3 or 4 years ago?
Yeah, that's a great question. I think there's a lot more education now for boards that have done multiple SPACs around what to look for. I think it's important that SPACs understand the nuances and that don't treat the insurance as a commodity. For instance, the length of the SPAC. It used to be, well, we'll just match the length of the SPAC to the length of the policy, right? So if it's an 18-month SPAC, we'll do an 18-month policy. I think we've educated and others have educated our companies that no, we should always do a 24-month policy, even if it's 18 months back, right? Because there are going to be extensions, there are going to be things that you do, and you don't want to have to go back to the carrier, pay more, have that issue. So one, always make sure it's a 24-month SPAC, 24-month period, regardless of the term of the SPAC, even if it's a 12-month. The second piece of that is make sure then that you can get terms that it's not fully earned, right? So you get a 24-month term, and if you get it done 6 months early, then 6 months of that premium can be credited against the runoff, which is another important piece, is the runoff coverage. Exactly, pre-negotiating what that runoff looks like, how much it's going to cost, way before the merger's ever even contemplated, is a key component. We have a program for NASDAQ-listed SPACs. Our rates for the program we've got caps runoff at 125% for 6 years, which is almost unheard of elsewhere. And so companies can take advantage of that and know that when they go into the de-SPAC process and they're creating a budget, that fee is capped, that premium is capped. Talked about a little bit earlier, who's covered, right? Sponsors are now asking, are we covered under the policy? They were not asking that 3 years ago. They weren't even contemplating it. But we've seen litigation where the sponsors are named. We've seen litigation where advisors are named that aren't even board members. So being very careful to make sure both the advisors and the advisory board and the sponsors are covered under a policy. And then they're asking now, do we need A-side only or ABC? A-side only is a policy that will cover only the individual directors and officers when the company is unable to indemnify them, has no money to protect them. ABC is more of a balance sheet protection, and most SPACs are not buying that, right? Because end of the day, all the assets are in trust. There's very little in the operating fund to protect it or to pay defense costs. So I would say 99% of SPACs are really looking at buying A-side only policies, which 3 years ago they were spending more to buy ABC with huge retentions that never came into play. So I think that's been the difference of the last couple of years, and pricing has come way down. I mean, 3 years ago, SPACs could be paying $600,000-$700,000 for insurance, and now it's down to $120,000, $130,000 on average. And I think that's because of the way the litigation has changed, and a lot of the exit source Cayman has reduced a lot of that exposure.
Got it. Okay. Next question again, Cynthia and Daniel, because of your expertise. Given the increasing cross-border nature of SPAC structuring, what should boards and sponsors be doing differently today to manage risk in both Delaware and Cayman?
Why don't you start?
Yeah, so I'll start. I think the process now between U.S. and Cayman law firms, I think it's important to engage early and make sure that what you're doing on the de-SPAC side links up with what needs to be happening on the Cayman side. So engage early and closely coordinate. So just thinking about the cross-border nature of the SPACs, I mean, I think some tips. I mean, I think everyone should be treating de-SPACs at this point as real IPOs and expect that they're going to get the scrutiny that an IPO would. That's certainly how the SEC is viewing them, and that's how private litigants will as well. I think both important in a Delaware and a Cayman context is to build a record around conflicts, how you're dealing with conflicts when they come up, how the board is working through their process and how those are getting resolved and disclosed, as well as around independence. So are independent directors, non-conflicted directors making those decisions? Are you getting a fairness opinion? Who's taking an independent look at the transaction to be able to provide for that fair value that you're looking for? And Cynthia, please jump in on that as well. Well, maybe I'll turn it over. Maybe you want to talk about that a little bit.
Yeah, I mean, I think from a Cayman perspective, what we do have the benefit is seeing how litigation has played out in Delaware. And I mentioned that a number of these claims haven't yet been seen through the Cayman courts, but we're able to kind of identify where there might be, I wouldn't call them pitfalls in practice, but maybe we're able to better identify what best practice should look like. So to Daniel's point, thinking really about process, thinking about documentation, boards approving LOIs before they're signed, boards really kind of front-ending a lot of this process, being involved, getting the fairness opinions that they might need, bringing in the independent advisors. Daniel, it's music to my ears that you want to have Cayman counsel come in at the start, but without kind of being too facetious about it, there is a different sort of process that we would go through. And as I mentioned, a lot of this is being tested under the constitutional documents that are fundamentally of a different jurisdiction to where securities actions might be brought. And so making sure that you have really stress tested what you're putting into place, I think, is really, really, really key.
Yeah, and I'll jump back in. I mean, we didn't get to talk a lot about SEC enforcement, but the SEC, even though they have expressed a lighter touch on disclosure documents, and CorpFin has let deals move quicker and has been more responsive, there have been a number of enforcement actions this year that have focused on conflicts, on fraud, and have actually focused on individuals as opposed to corporate entities. And so I think that we're seeing less SEC enforcement. I think it is looking at more serious cases and taking more definitive action. So when you're thinking about the de-SPAC, which is most of where the risk is on the securities law front, I think what you want to make sure you do is make sure that the redemption decision that public stockholders have is fully informed. So making sure they know what the board looked at, and that they understand the full context of the deal and what it means for them in terms of conflicts, in terms of dilution, and in terms of the underlying company's business. The other thing we should mention is projections, right? Projections are slowly coming back in various ways, and the new rules a few years ago basically said SPACs clearly don't have the safe harbor, and so we should be thinking about projections in that context when they go in front of boards, if they do. And the other piece is just to remind folks again, the de-SPAC process, deals are recut constantly through that, and I think we all experience that. But as the deals change, as sponsor economics change, maybe a sponsor needs to put more capital in, and that comes with a benefit for taking on more risk. That also has to weigh into the conflict, independence, and other determinations throughout the course of the transaction. So just because the board approved the transaction and the BCA got signed, the work of ensuring that the transaction is litigation proof doesn't end at that point. It continues all the way through closing.
Great. I think we're running down on time. I'm going to mention one last topic, which actually I've been mentioning for the last several years. We as trustees face issues surrounding extension payments by sponsors, and we've been trying to engage with other partners in the industry, law firms, bankers, etc., to come up with a solution, because we've encountered a large number of SPACs where the SPAC has not made its extension payments or is low on their payments, and there's really no enforcement mechanism historically to make the sponsors pay up. So we actually finally came up with a mechanism. So we've put into SPAC IMTAs a provision which requires the payments to be made, and if they're not made within a cure period, they're in jeopardy of their end of life coming to be and facing liquidation. We've also taken some old SPAC IMTAs and arranged with the issuer to amend for a similar purpose. So I think we actually are coming up with a solution after years of agonizing. We've had some sponsor groups that had hundreds and hundreds of thousands of dollars of extension payments that weren't made, and we're seeing that disappear slowly, but it's reducing. So that's an added advantage and a change. Any other questions from the panelists? Questions from the floor? Hearing none, seeing none. Thank you very much. Lunch is on. Thank you.